Okay, thank you for inviting me to speak, and Taylor Jazeer is another lawyer that works with me. So we're here to answer your questions about wills and powers of attorney and medical decision makers. So we're based in Werribee, so we're in Synnott Street, but we see people everywhere. Melbourne, I live on the Ballerine estate, so we see people there. We see people around the world, in fact. So we have some clients who live in other countries, in other states, because we do lots of things virtually. COVID taught us that we could do that. So this is a presentation that we give to lots of people, but it's not intended to be individual legal advice. It's just informing you about what we think is important when you're considering making a will. So a will is a legal document that essentially expresses how you want to dispose of your assets. So the things that you have, like money in the bank, a house, a car, a caravan, jewellery, artwork, shares. If you've got a business or a family trust, you can deal with all of those things in a will. Now the will, you can make at any time as long as you have mental capacity to do so. So that means that you're able to understand what it is to make a will, and that you are of right sound mind. You can make a will at any time in your life, and you can change it. It doesn't have to be a set document, okay? Because your things will change. For example, when my parents made a will together, like they made a will, my dad made a will, mum made a will, they said the same thing, but each individual has to have their own will. And when they made it, myself and my brother and sister were young children, and then it wasn't, they never changed it. We grew up into the adults and they still didn't change it. And then my father passed away, and the executors, which I'll talk to you about then in a moment, had passed away. So when my dad passed, my mum redid her will to make it more up to date. And since then she's changed it a few times, because then, grandchildren came along and great-grandchildren came along. So they can be changed. So as long as you've got capacity, that you understand what it is to make a will, you can do it at any time. You've got to be, of course, over the age of 18 to do so. And you can't be influenced by other people. So often, particularly with elderly people, like one or two of their children might come along with their parents saying, my parent wants to make a will, and we're a little bit cautious about that. We want to make sure that it's their decisions and not their children's decisions, so we speak to them alone. We ask their children to wait outside, and we go through everything with the person who wants to make a will, and we decide then whether we are going to let the children in or not, and how comfortable the parent is. But we can generally tell when people are being forced to do things that they don't want to do. So why have a will, or why update your will? As we said, circumstances change. It's a way that you tell your loved ones of your wishes, how you want to distribute your estate, how you want any debts to be paid out, and who should benefit from your estate, and who should manage your estate when you're gone. So it gives you some peace of mind, and you're not leaving the whole worry to somebody else. So you should choose the executor or executors that you feel most comfortable with. You should always update your will when there are significant changes in your life. For example, if you get married and you had a will, you should change the will, make a new one to take into account your new married life or your de facto life. When you have children, when you get divorced or when you separate, you need to think about redoing your will. A de facto relationship, so dying without a will, might mean that your de facto misses out because they have to prove that they were your de facto. With a marriage, we have a marriage certificate. It's pretty easy to see. But with de factos, it's not that case. So who is it? Often people say, what is a de facto? We hear it all the time. Oh, they can take my money if we've been together for 6 months. And I say, well, no, they can't. So a de facto is somebody and you don't necessarily have to live with them, but you have to be in a genuine domestic relationship. You might live in 2 houses, but you might share finances.
Other people know that you're a couple together, but usually you've got to be together for 2 years before you're classed as a de facto, or you've got a child together, and you could be classed as a de facto. So if you've got a question while I'm saying these, I'm happy for you to yell out. If you don't want to wait till the end, that's fine. What are the consequences of not having a will, or if a will is not valid? Often people will just write a note. Like we had a case recently where a year and a half prior to her death, she was very unwell, she was in hospital, and she wrote some notes in a diary. She didn't sign it, it did have a date, but who knows who could have written that. She then passed away without a will. So it's become a bit of an issue. In the meantime, the husband and wife had separated, but they never divorced. And they had children together. So then the deceased family thought they should get some of the money, and so there's been a bit of a dispute about that. So the whole thing then would come down to, was that a valid will? And on advice, we say no, that was not a valid will. So because she didn't have a will, her husband got it because they weren't legally divorced. I did a divorce for somebody after they'd been separated for 20 years, and during the period of applying for the divorce and the divorce hearing, he died. It meant the wife was the next of kin because they were still legally married, so she had to apply for probate to call in the assets. There wasn't really any assets other than superannuation. So it's wise to have a will, and it's very wise to get it drafted by a lawyer. You can go to the post office and pay $29.50 for a will that you can fill in. And yes, they can be valid, but sometimes they're not valid. If you've got a property and you want to make sure that your property goes to the right people upon your death, then you should get proper legal advice and do a will. So if you don't have, if you don't have a will, then if the law says there's a regime of who the money goes to. So if you die without a will and you are single, it will go to your parents if they're alive. If they're not alive, it will go to your siblings, brothers and sisters. If you have nobody, none of those, we look for the next person that might be eligible. If you're married, it'll go to your spouse, a certain amount of money, and then some will go to your children. If you've got children from different relationships, there's different formulas. So it's important to get legal advice. A lot of people think if I don't have a will, the money goes to the government. I can tell you it does not. We look for somebody who is eligible. So one day I got a call from a woman I know who worked in a school, a teacher, and one of her colleagues died. She died without a will. She had no relatives here. No one. She was single, she'd never been married, never had children, never any relatives here. The only living relatives she had was her cousin, who was 95, and that cousin's son. So because she died without a will, we had to do letters of administration and make that application. A lot of work when they're both in England. It cost quite a bit of money to do that. Lots of backwards and forwards. However, the estate was worth quite a bit of money, more than $2 million at that time, which was a while ago. So the cousin, who was 95, became a millionaire overnight. She didn't enjoy it, I'm pretty sure his son did. So they're the reasons why you should have one. So in a will, just to quickly go through it, the will is going to record your name. Right? So one of the important things is that whatever your name is on your legal documents is in that will. And if you're known by any other names, then you have to put those names in there. I use my family's example. My sister's legal name is Maria Dolores. She never uses that, she uses Doris. So some of her documents are Maria Dolores and some of hers are Doris. So we must include all names that you're known by. And when you come like as migrants, like my family did, and I think probably all of our families did, sometimes they change your name. My surname is really Ebejer, but nobody says that in this country. So we say Ebejer. My parents got sick of telling people the J is like a Y. So it's written the same way but pronounced a different way. So we also put your occupation in and your current address. We then pick people who are going to be our executors. So they're the people that are going to, personal people, who are going to step into your shoes when you pass away, and they're going to manage your estate. So you must pick people who are over 18 and who are going to be able to be honest and who are going to be able to do the job. Those people generally come to a lawyer and work with a lawyer and instruct the lawyer. So we need their full names, their relationship to you and their address. The next thing that the will says usually is, let's pay out all my debts and funeral expenses and the expenses to dealing with my estate to wind it up. You can add gifts or bequests, you can leave money to charities, you can leave a gift of this ring goes to my son upon my death. So I'm naming a specific thing, or I want $10,000 to go to my niece. So you can say all of that, and then the rest goes to your beneficiaries. So usually if it's a partnership, a husband-wife, de facto couple, usually people say it goes to the other person, and if they don't survive me and they've got children, it'll say it goes to their kids in equal shares. We also look to the future, so you don't have to keep changing it all the time, but sometimes we'll add a clause in that says, but if a child of mine doesn't survive me and they've got children, it goes to the children. So we talk to people about all of those options that they have. So the will actually just records your directions. Okay, you can even put a clause in if you've got children under the age of 18, who would look after those children? Who would become their guardians if something were to happen to you? You can put details in of who you're excluding. So after getting legal advice, you've decided that you don't like your child for whatever reason, you haven't seen them for a long time and you want to cut them out. You can put that in your will if you want to. I'll come to that in a sec. You can put in your funeral directions, but we always say you can do that. You can say I want to be buried at this cemetery, I want to be cremated, I want my ashes to go to my homeland, but you have to tell the people living while you're living, because by the time they find your will, it might be too late for that. The will must be signed in the presence of 2 independent witnesses for it to be valid. So it has to be signed and their names have to be clear, and of course you have to sign and date that will. So as I said, an executor can be anyone that you trust, who you feel could do the job. You can have 4 maximum. That is too many because they will never agree. We always say you should have at least 1 and an alternate. So if the first one isn't available, or they predecease you, they can go to the second person. So as I said, they generally work with a lawyer to apply for probate if there's a will, and if there's no will, it's called letters of administration. And they have all the power, as you did while you were alive, to deal with your finances. So we said you can put in a clause to exclude somebody, and if you're going to be thinking about that, we always suggest that you write a letter at the same time as doing your will to say why you're leaving somebody out of your will. Okay, but let me tell you, there is no guarantees that that is going to be upheld by the court, because we find that most people who are left out contest it. So once probate is granted, a person has 6 months from that date to contest. So, you can, and people come and say, oh, I've been told if I give $1,000 to that child I don't like, that'll be okay. No, it is not okay. It all depends on the circumstances, the size of the estate, and who the other beneficiaries are. So it's always good to get advice about that. And just tell me about time if I'm going over. So who can challenge wills? Not everybody can challenge wills, but a spouse or a de facto, a child, a stepchild, and others who can make a claim in certain circumstances, like a registered caring partner, grandchildren, and members of the deceased household. They have to be able to demonstrate financial dependence. It includes in-laws as well. So if you say you had a child and they were married, and then your child died, but you didn't leave anything to the in-law, they might contest it. they can do that. So it's really important to keep updating and documenting any of those strange relationships, those relationships that are not working, about, you know, that you haven't had any contact with them. So you need to consider the costs and stress for those living. We've got a few challenges at the moment, and it's very, very stressful. And not only that, it costs a lot of money. And when people take it to court, the first step is mediation. Up to mediation, each side, so the estate and then whoever's contesting, is paying around $35,000. So you're thinking that's $70,000 already. And if it goes to a trial, which not many do, it could be hundreds of thousands of dollars. So it's very important that you consider who you're going to leave out and why. I've already really talked about that. You should also look at, when you're making a will, if you do have a partner, if you're married or a de facto, and you own a property, you should check how the title of that property is held. Because if the property is held as joint tenants, you don't put it in your will, because as joint tenants, the survivor will automatically get that property. So often we get people who come along and say, I want my share to go to my children. And when I look at the title says joint tenants. And I say, we cannot guarantee, you cannot do that. It'll automatically go to your husband or to your wife. The way that you can do that is the title has to say tenants in common. Tenants in common in what shares? So say I own a house with my partner, there's 2 shares, I own 1 share and my partner owns the other share. I can do whatever I like with my 1 share. I can put that in my will. He is not going to automatically get it. So we often ask, if you come to us to do your will, let's find out what your title says on your property. So that's my little talk on wills, very brief. So wills are for when you are going, they come alive when you're dead. Okay, powers of attorney are for while you are living. So you can make a power of attorney, which means that they deal with financial issues and personal issues. You're going to appoint somebody to act on your behalf for whatever reason. One might be, if it only comes into play if you lose capacity, you get dementia. You're involved in a car accident and you can't make decisions. So you can make it why you can make decisions, and you can give somebody that decision making in a power of attorney, and they step in your shoes when that power is enlivened. Okay? That power of attorney, when you die, it dies. It can no longer be used. Some people get in trouble because they still take money out of bank accounts and deal with that when the person's died. You cannot do that. A person who is appointed as an attorney under a power of attorney, if they're acting in that role, then they need to keep records of any financial transactions that they do. Unfortunately, we see a lot of elderly people get abused with powers of attorney. There is no register. A lot of bank people know a client because that client's been going to their bank for a long time, and then they can tell something's going on with this person's money. So it's really important that whoever you pick as your attorney or attorneys are again people that you can trust. And again, we suggest that you get advice about that. Anyone, you have to be over 18, the attorneys have to be over 18. This power of attorney can consider things like, whether you can still live in your own home if you become too unwell, whether you should maintain connections and family, close friends, retaining community links, whether they take you to specific events. This is a big issue. I took out $1,000 from my mother's account to pay for my child's birthday party. When the grandmother had capacity, would she have paid $1,000 for your child's birthday party? The answer is probably no, which means that the attorney is acting fraudulently, and we do see that. So it's good for people to write that within their power of attorney. I can say from our experience, people never give us those instructions. They just leave it general, but we do talk to them about that. Another thing that an attorney can do under a power of attorney is sell your house so that the funds can be used to pay for, say, a nursing home. So we say you should do a power of attorney, and you should do it while you've got capacity, but you should make it that it doesn't come into play until you lose capacity, and the doctor says that. You can use power of attorney on an interim basis. For example, I once went overseas, and when I was there, I was selling my house, and the auction happened to be on while I was away, so I appointed an attorney under just a specific power of attorney that they could sign the contract on my behalf, but they had no other power, and it ended when that contract was signed. So again, someone you can trust, somebody who can understand financial transactions. No use giving it to somebody who gambles, wastes their money. They're not the person to pick. So you've got to choose appropriately. The power of attorney, as I said, lasts forever unless you cancel it or when you die. Yeah. Then the other one, again, you need 2 witnesses. They have to be not connected to the attorneys. The attorney has to sign a statement to say that they understand their legal obligations. So they have to accept it. The other form that we get people to do, again, it's for while you're living, is a medical decision maker. So they used to be called powers of attorney for medical. If you had one of those, they're still valid, but today they're called medical decision makers. And it's the same thing. You could pick up to 4 people, and what it is they go to, if you became so unwell and you couldn't make a medical decision, they go to the first person on your list, and that person can say what happens to you. And they keep going down the list. Most people pick 2. So the same things has to be witnessed. We need addresses, phone numbers, dates of birth of those people. This is my very quick talk on that topic, and if you've got questions, please ask now. Yeah?
What could make this document invalid?
What could make it invalid? People write on it after it's been signed. We've had that. People add clauses after it's signed. It's not validly witnessed, so it hasn't been 2 people, so it might only be 1 person. Some things technical, like, for example, today we found a will, a very old one, that was dated, let's just say the 19th of May, but the cover said 16 May. So what we had to do is go back and look at the file. It's an administrative error, and that's okay. It just means we have to do a bit more work, and we have to do an affidavit, a sworn statement to the court with evidence that it was actually signed on the 16th, not the 19th. So it will still be a valid will. And it was, yeah, so that can be an issue. But yes, most of the time they're not valid if somebody doesn't have capacity. So after they die, somebody comes and says, my mum had dementia. You know, at the time of making that will, she had no idea. So we would have to, the court would want medical evidence, and then that will would not be valid. That happens. So we ask people sometimes that we used to ask for a doctor's letter to say that the person had capacity to understand what it means to make a will. Now we want the doctor to put it on an affidavit, so a sworn statement. Because what happens now is when somebody dies, you get 2 death certificates. One death certificate just tells you about the death, the other one tells you the cause of death. So the court wants the cause of death one, because they want to see what did the person die from, and how long did they have that illness, and was it around the time of making that will. So there's lots of different reasons. Any other questions? Okay, we've got a little show maybe you can take in it. It's actually got a summary of everything I talked about. Thanks.
Good evening, everyone. I'd like to acknowledge the Warong people who are the traditional owners of lands on which we're meeting today in Truganina. Is anyone here? So whereabouts are people from? Are you sort of from mostly from Tiny, Truganina, or further away? What suburbs are you representing today? Tiny? Yeah. Truganina. Okay, good. Alright, just I don't want to talk about stuff that's completely irrelevant. What are you talking about? So anyway, thank you for taking time out of your day to be here. Before I start, maybe I'll also mention I do work a little bit with some domestic violence matters. I do a lot of migration law matters as well. With the family violence matters, one interesting thing that I learned, and I try and always pass on to community members, is when someone makes an allegation against your family violence, there's a sort of a tendency to feel like, oh, but they did this to me, and sort of throw back claims of family violence, thinking that that will kind of reduce the severity of the violence that they're accused of. But often it tends to multiply the effect of the family violence situation, such that sometimes if the police feel both parties have been very violent towards each other, then they may need to protect the child from both parties. So that's something I feel like is important for community members to also be aware of. So today's conversation for me is really about how we can make communities safer and more resilient. I do wear a few hats. I'm the principal lawyer at Averos Legal. I support community organisations as a consultant with Ebejer, and I serve as the president of the Troglodyne Residents Action Group. And through these roles, I've seen how crime affects people, from victims who are desperate to be heard, but also to the accused who sometimes just want fair treatment under the law. My history before setting up my own practice is in regulatory law, working at agencies like AUSTRAC, the Higher Education Regulator. With AUSTRAC, I was involved in investigations that resulted in some large penalties for entities like the big casinos relating to money laundering and things like that. I work directly with residents on the ground through the TRAG, and I meet regularly with the Wyndham Local Government Area Command Police as a neighbourhood representative to talk about these issues. Obviously, resident-led crime prevention is not a replacement for policing. It's more of a practical and empowering strategy for us to implement while we wait for the relevant resources that we deserve to come through from government or police spaces. The responsibility is obviously on the police and state to keep us safe. That's why we pay taxes, that's why we vote. So I'm not saying that we should all really take that and do that as a second job, but obviously while waiting for outcomes, there's things that we can do. We need more police on the ground, we need faster response times, but we also need targeted action in areas like Tani and Truganina, because the population growth has exploded. There's no police station, for example, in Truganina. There is a semi-police station in Tani, so and people say that it's very difficult to go in and meet with a police officer because they're quite understaffed. Patrols of police are also something that's said to be quite rare, and often you call and by the time you get here it's too late. But yeah, we do have control as neighbours and as community leaders and as residents to want to do something in this space. And yeah, tonight's about practical community-driven solutions to reduce the types of crime that hit us the most regularly. The opportunistic theft, car break-ins, parcel stashing and petty vandalism. Oftentimes for the police that's nothing. They're dealing with more serious stuff. They don't have the time to spend an hour with us dealing with it. But it might be really impactful for you. So I had stuff stolen out of my car. Probably initially I thought it was just like $200 because it's just a cricket bat and some cricket. But later on I realised, I actually had a work bag in there. I was portable hard drive with priceless photos from 10 years, all this sort of stuff. So there's always an opportunity to do something. An example for me, the reason I've got up like this up there is it's an example of something that I've recently been more and more involved in, which is trying to make sure that any hate crimes that happen in the community here get the attention they deserve from the police. And a recent example was a hate crime in the Ebejer shopping centre, which you might have seen in the media a little while ago, where a woman was separately targeting two mums and assaulted them based on what they looked like and the religion that they were perceived to be from. And when this victim shared, and I was personally supporting the victim as an advocate on that matter, so I know that when the victim shared her experience with the police, initially they got the legal support, but they were not asked to make a police statement. And then that night the victim went away and wrote on a social media page what had happened, and another man decided to personally threaten this woman, saying that he's going to break her legs because she's talking about this stuff on the Wallet Facebook page. When the victim then went to report that to the police were like, oh, are you sure? I don't think anything's going to happen. Here's a card, like, call me if anyone actually gets to you, which is obviously, by that time, it's too late if someone does actually follow up on a threat like that. So that was an interesting experience because just months ago I tried to help another woman who was also on my ride, who was bashed outside in Truganina, outside the shopping centre, and we didn't get really much of an outcome from the police. They didn't respond very quickly, and by the time we chased them, it was too late. Like, there was no evidence. The CCTV was gone. The victim was probably long gone. The attacker was probably long gone from the area. So this time, how we advocated was by writing to the MPs and the ministers. It helps when there's an election happening. They're always paying attention. And then we met with them, and we really pushed them to push the police as well to act on this. And within days, they were able to actually apprehend the woman who had attacked these women. So this is an example of, resident-led crime advocacy. Sometimes it's very hard if you experience crime for you to go and tell the police, no, this is important, I need you to do this and that. But there are people out there who can help you. I think WestJustice also probably can direct you to organisations that can assist you with these sorts of issues. That experience taught me that we can't always wait for someone else to step in. Sometimes we have to be the ones pushing, organising, and acting. And that's also for the everyday stuff that we've talked about so far. There's 4 strategies we've come up with at the Truganina Residents Action Group that we're really focusing on at the moment for crime prevention. One of those is obviously connected neighbourhoods. So, would you say you know your neighbours on both sides? Does anyone know both of the neighbours next to your house? Yeah? Yeah, everyone? Yeah, that's good. Do you know everyone on your street? No? We're all very busy people. It's very hard to get there, right? So we're really encouraging people to get to know their neighbours. Not just the next door ones, but also a couple of doors down, meet them, get to know them. Build a resilient neighbourhood, right? Not just a wave, but know them, have their phone numbers. So when you leave your garage door open, they can text you at 1 a.m. and say, hey, what are you doing? You might want to close that. They can spot a stranger at your door if they know you while you're away. They see someone, they know who you are. If something's stolen, you've got 3 other houses checking their cameras, and it's not awkward. It's like, hey, I've never talked to you before, but can you check your CCTV for me? Right. And if a teenager is acting out, maybe they're related to someone on the street, you can actually go and tell the parent or tell someone, hey, something's messed up here and he's knocking on doors at midnight all over the street. Something might be able to be done. So we're encouraging each street to build a digital contact tree, 1 WhatsApp group, 1 shared Google sheet with basic contact details, or it can be just a Facebook Messenger chat. In many estates, there are already Facebook-based resident groups, Facebook groups. And they're a really good place to go and connect. Some of them are not as active as others, but that's one really good place where you'll get notified if suddenly there's an accident next door or in the next street next door to you, if you're part of the right platform. The other second strategy is really all around CCTV use. So I know for myself, I'm a bit of an overthinker. I analyse too many things, and it takes me a million years sometimes to get to the point where I'm like, all right, I'm going to buy that CCTV camera. And I think a lot of people in that community are similar. Sometimes they can't afford it, so it might be too expensive. And at other times they might just need some peer pressure to help them kind of make the jump. So with the Truganina Residents Action Group, we've identified no-cost solutions to CCTV. So there is an option where you don't have to pay anything, and you can have a camera staring outside at the front door when people are coming in and out. And obviously the paid solutions we've got in terms of quality or how long we retain them. So what we're going to be doing is talking through that, so that rather than you having to go online and talk to a Bunnings guy and work out what to buy, how to install, what's cheaper, what's not, what's cost effective, what's worked for, you'll know what's worked for your neighbour, basically. So that it's a lot easier for you to make that decision to jump and have your own CCTV, but also where to point them. So it's not just about having CCTV. one issue we found is the opportunistic thieves who check the car doors every night, they tend to drive right on the middle of the street, and passengers get out with hoodies or whatever and walk and check the doors. So often none of the CCTVs pick up the number plate, which makes it hard to identify the car. So we're looking to tackle that by having cameras that can actually catch that number plate on smaller streets in suburbs. So when you call the cops, you can actually say, no, I know what car it is. And yes, sometimes it's stolen, but even that is actually really good information, because one of your neighbours down the street will suddenly, finally know that this car's been picked up, and they'll get it back. Think about angles. Whether there are angles that are running place, these sorts of issues. Where would someone park there? And don't rely on audio alerts alone. Review the footage visually if you already have the CCTV. The other point, we're looking at our GPS trackers. So we'll be looking at the sort of legal implications, privacy considerations, all of this sort of stuff. But generally, GPS trackers on vehicles outside your house might be helpful for real-time crime prevention. Even if it's not every house in the area, then you still have, even if it's just one car where the police were able to track it down within hours, that may make your neighbourhood safer from that kind of theft, because the cops won't know if it's one car or 100 or 1,000 or every car is that. Sorry, not cops, thieves. And the fourth item is resident-led patrols. So some of you might have heard about the mobile car patrols. I think that are proposed for the Truganina area. Not sure, you might not be aware though that Wyndham Vale's Jubilee Estate and parts of Mandarin already have private security patrols that local residents got together and funded because of the sheer amount of sort of criminal activity happening in those areas. And YPG risk guards patrol the area. So initially you might be a bit skeptical, like, can they actually do anything? They're just going to be driving around in a car. But I've been advised that they have made citizens arrests. So the security guards can actually potentially arrest someone that they see who's breaking into a car and wait for the police to arrive to apprehend them, rather than just take a photo or watch them run away. So we'll be looking into resident-led patrols and how we can encourage community members to support those patrols. And then, so what can you do tonight is really the final segment of this, and a short checklist might be, knock on your neighbours' doors, introduce yourself, join or start a local WhatsApp group for your street or your local suburb. Check your CCTV placement if you've got it. Make sure it is actually working properly and you can catch that car if it's possible to set it up such that you can get the middle lane of the road in front of your house. And consider trackers. So similar to the CCTV, we're going to do all the research to make it easier for the community to make a decision as to whether they want to get a tracker or not. And alongside the trackers, we're also going to have stickers, which will basically act as a deterrent for those who may or may not have the trackers, to just make it more difficult for them to guess. If you want to find out more about some of this stuff or contribute, you can visit the Truganina Residents Action Group Facebook page, or email trugresidents@gmail.com to get involved in our Safe Neighbours Initiative pilot project. We'll connect you with others who want to take action and help you build sort of your street contact list. We'll just create a stronger, more connected community, and hope to hear from you about your ideas and how you might be able to get involved, or any questions you might have about stuff.
What was the email again?
TRUG. So TRUG. Truganina.
Trug at
Residents. Trugresidents@gmail.com.
Thank you.
Any questions about? Did I say anything about PMCs? No, I didn't. So one final tip in terms of dealing with police: if you do find yourself as a recipient of a hate crime, someone says, go back to where you came from, accompanied by a client, it's very important that you tell the police officer that arrives that you want the matter to be treated as a prejudice motivated crime. And if you find them to be dismissive, it's important that you reach out to an organisation that can offer you some advocacy support. Because in my experience of dealing with this for many, many years, helping people who have experienced these things, it's very common that it can be minimised. Police are a lot better now than they used to be, but it's always helpful to have someone to help you through the process. Any more questions?
Thank you, everyone. So, the acknowledgement of country, which is the next slide, Sheikh has already done that, so I won't go through acknowledgement, but thank you for doing the acknowledgement of country to begin with. So today, what we're going to look at is just some general information about WestJustice's service, some information about the program that I manage, which is Women and Gender Diverse People's Rights Program, and also information on family violence intervention orders, including what is family violence, how to apply for an intervention order, police applications, court processes, breaches of intervention orders, changing or removing intervention orders, and then some time for questions. So just briefly about WestJustice, we're not a government agency, we're not Victorian Legal Aid, we are a community legal centre. So we service Melbourne's west, so that's the Wyndham Council, Maribyrnong, Hudson's Bay, Melton and Broome Bay. And we provide free legal advice, as well as social work and financial counselling services. And we also do a lot of community engagement, like today, and also advocacy for systemic reform across our impact areas, which is workers' rights, children and young people's rights, women and gender diverse people's rights, and economic and housing rights. If we could go to the next one. So just a little bit about the areas of law that we do at WestJustice and some of the areas we don't do. So we do family law and family violence, and that is the program that I manage. We also do employment law, criminal law, fines, infringements, tenancy and housing, motor vehicle accidents, consumer law matters, debts, mortgage, wellbeing and financial counselling. We also have a school lawyer program where our lawyers go to specific schools in Wyndham so that children or young people can access legal advice at school. What we don't do is just immigration visas, wills and estates, conveyancing, personal injury, commercial law, guardianship and administration. So it's great to have such a full panel here that represents all the other areas. Okay, so looking at what is family violence. So family violence is harmful behaviour that's used to control, threaten, force or dominate a family member through fear. It can include if someone is physically abusive. When we talk about physical abuse, it could be hitting someone, pushing them, slapping them. It could be also making threats to physically harm them. It includes sexual abuse. It also includes emotional and psychological abuse. So that would include, for example, controlling who a person can see and when. It could mean putting someone down. And it also includes economic abuse, such as forcing or deceiving a person to get control of their money. So it might be, for example, asking someone to sign up for Centrelink benefits and taking that Centrelink benefit so that the person who's applied for it doesn't have control of that money. Family violence is also a behaviour that makes a family member fear for their safety of their property, another person. And children are also included in that. So if the child witnesses or hears or is around the family violence, then they're also covered by the law. Okay. So what is a family violence intervention order? It protects someone from a family member that's using violence. So it can protect the person, children, property. It's made in the magistrate's court by a magistrate who's satisfied that a person has committed acts of violence against a family member. What an intervention order can do is restrain the person who is using that violence, and they're called the respondent generally, from contacting another person or being within a certain distance of where they live, work, attend school, even out in public. It also prevents them from being in their own home if they live together. Important to note that a family violence intervention order is a civil matter. It's not a criminal matter unless it's breached. So it's a civil matter, but if you are the person who the order is against, so you're the respondent, you have to comply with the conditions of the intervention order. If you breach the conditions of the intervention order, then what can happen is the police can charge you criminally for breaching the intervention order. And if you're found guilty of breaching a intervention order, then there's serious consequences. It can be prison, there can be fines, but you'll also have a criminal record. And just to sort of define what a family member is, so it's people who share intimate personal relationships. So it could be a spouse, if you're married, it could be your de facto partner, it also includes, for example, your children, your parents, relatives by birth or marriage or adoption, people that you treat like family members, or are related to you within the family structure of your community. Now, applying for an intervention order, and I've got a lot of slides, so I'm just going to talk to them more generally and not necessarily go through every single slide. But if you're in fear for your safety, you can apply for a family violence intervention order. If you're an immediate risk for your safety, you can call the police on 000, and the police can attend your home or where you are, and they can apply for a family violence intervention order on your behalf. You can also go to the police station to report a family violence incident, and the police member may apply for an intervention order on your behalf there. If you make your own application, the way that you would make your own application is you can visit the Magistrates Court of Victoria website and make an application online. There'd be an application form that you would fill out, and it would then be registered with the court, and they will contact you to then set a time to meet with you. Because what the magistrate wants to know is, do they need to make an interim order? That's an order before the matter even comes to the court to protect you, to keep you safe. And they may do that. What will then happen is that your application for an intervention order would be served by the police on the person that's using violence. So they're called the respondent. Now, with the, so you can go down that path in making it, or you can attend your local magistrate's court. So if you're having problem, if you can't read or write, if English is not your first language, you can attend your local magistrate's court in person, speak to the counter, the registry, and they can help you make that intervention order. So anyone can make an intervention order if you are over 18. And you can also include your children on your application. They also need protection. You can apply for an intervention order at a children's court if you are between the ages of 14 and 18, and if you're an adult, that you're applying for your child only and not yourself. And as I said, police can also apply for an intervention order for the protection of you and your children. And it's important to know that police can make that application even if you don't want it. So if they've been called out to an incident and they assess the situation as very serious, they could apply for that intervention order even if the person that experienced that violence does not want it. And then it will be up to the magistrate to decide how the matter goes if there's people that are contesting it. Intervention orders and parenting orders can sometimes, a lot of the times, they interact. So intervention orders only deal with family violence and they're separate from parenting orders that may be made in the family law courts. So when a magistrate makes an intervention order to protect a child, they have to also check if there's parenting orders in place, and they can decide to suspend, vary or discharge or cancel a parenting order if certain conditions are met. If you have an intervention order and you have children and there is parenting orders in place, or if there's no parenting orders in place, it's really important that you get advice from a lawyer before making contact in relation to spending time with your children. It really depends what the intervention order says. What happens once an intervention order is made and the respondent served with that intervention order is then it will have a first court date. Now, at this first court date, the respondent, so the person who the order is against, has options of what they will decide to do. So, for example, they could agree to an intervention order being made, or they could ask for an undertaking instead of an order. Now, the difference between an intervention order and an undertaking is that an intervention order, as I said, is a civil matter, but if it's breached, it becomes a criminal matter. Whereas an undertaking is not a court order. It is a promise to the court and a promise to the affected family members not to commit family violence. So if you breach an undertaking, you can't be charged criminally for breaching that because it's not a court order. However, what would likely happen is that the applicant, the person who applied for the order, whether it is a person or the police, can bring the matter back to court and have it reinstated to say this person can't comply or follow their own promise and an order is needed to protect the family. So the other options include arguing against the order. So that means you don't agree to an order being made. If you don't agree to a matter being made, there'll be more court dates that would come, and then it would come to a final hearing where both parties could bring any witnesses or evidence they have, and the magistrate will listen to any witnesses and the evidence from both parties and decide whether the intervention order was being made. Another option is, if you are served with the intervention order, you can ignore the summons and not go to court. Now, if that happens, the court will likely make an order in your absence. They may not do that on the first court date. They might adjourn it or adjourn the date, put it to another date to give you another opportunity to attend. And if you don't attend the date, they can make an order in your absence. And the length of an intervention order will be determined by the magistrate. Generally, a lot of orders are for 1 year, but sometimes they can be for longer periods of time. And where it's extreme family violence, it could be a indefinite order. Really important about getting legal advice for intervention orders. Whether you're the applicant, you're the respondent, and if the police make the application, they're the applicants, but the affected family member can still get legal advice. So you can request to receive legal assistance from a duty lawyer at court by contacting the magistrate's court where your matter is listed, or online, and I think there's a link in there where you can request for assistance. If you're responding to an intervention order and you're applying for any type of visas or Australian citizenship, it's really important to get legal advice from a migration lawyer before agreeing to a family violence intervention order, because that may affect your citizenship application or type of visa when you look at character tests. Now, generally the duty lawyers, they won't be able to give you that migration advice. They're generally going to be lawyers that deal with family violence, family law, criminal law. And with family violence intervention orders, it intersects or interacts with lots of areas of law, such as family law, migration, criminal law, child protection law. So if any of those apply to you and you have an intervention order, or you're about to go to court for an intervention order, it's really important that you get some legal advice. So the next slide, I've talked about what police can do about family violence intervention orders. I've spoken about this already, so I won't go into too much detail. But police can, if someone's used violence, they can search your home, they can take any weapons, guns that they think you've used as part of the family violence, or that you may use. They can also refer you to support services for emotional and financial and legal support, and they could refer you to places where if you need to find somewhere to live because you've been excluded from the family home, that you could contact as well. Police can also, if they are attending an incident of family violence, apply for what is called a family violence safety notice. So they would do this, for example, if it's after hours on weekdays or Saturday and Sunday or public holiday and the court's not open. It works immediately, so they can issue the family violence safety notice. Family violence safety notice works exactly the same way as an intervention order. You must comply with it. If you breach it, you will be charged criminally for breaching it. Just as a reminder, even though you might live in your family home, that home might even just be in your sole name. But if there is family violence that has occurred, the police can remove you from the home, and they can also apply for that intervention order to exclude you from that home. And that's where you will then need to get some family law advice in relation to whether your relationship has ended and whether you need to do a property settlement, and also look at parenting arrangements if there's children. As I said, I've moved on to breaking the intervention order. So if the respondent breaks an intervention order or a condition in it, as I said before, they can be charged with a criminal offence. Okay? If you're found guilty of breaching an intervention order, the court finds you guilty. The penalties you can get is prison for up to 2 years, a fine of up to $24,000, a good behaviour bond or other penalties. It could be attending counselling or a behaviour change program. If you are charged with breaching an intervention order, it's important to get legal advice so that you know what your rights are, and you can also look at getting representation for that court hearing. Also very important to know is that, and we see this a lot, is when people get an intervention order or the police have applied for the intervention order, And then the couple decides, well, we don't want that anymore and we're going to reconcile, we're going to give our marriage another go, our relationship another go. And then they decide, well, let's just move in together. Now, if there's an intervention order in place, you can't do that. No one can just change a court order. You would have to go to court to have that changed. So you would need to apply to either have apply to revoke the order or vary the order. And then the matter would be before the court and it will follow the same process in regards to attending court, letting the court know why you want it revoked, why you want or varied. And if you're the respondent, you'd have to ask the court's permission to vary or revoke the order. And the reason that's really important is because if you decide to, live together again because you're giving the relationship another chance, and there's still that order in place, it means that the respondent, whoever the order is against, is breaching that order and they can still be charged criminally for breaching that order. And it's important to know that with intervention orders, it's the respondent that has to comply with the order. They must follow the order. The applicant or the family member, it's not against them because it's made for their protection. So if someone has an intervention order against you and they contact you, they're not breaking the order, but you may be breaking the order if you respond. So it's really important to get legal advice and understand all the conditions of your intervention order. Again, if you are the person that needs protection, it's important to carry your intervention order with you. It's a good idea to keep it in your glove box. If there's places that you attend regularly, the children are included on it. You might want your children's school or childcare to have a copy of that so that they can contact you and the police if need be. That's it. And any questions from anyone? Yes?
Yeah, no, domestic violence is quite a big issue at the moment. I'm just question is in your practice, have you come across a specific culture background people are having these issues, or is it common issues in Australia at the moment?
So common issues?
Is it a common issue, or is it cultural specific issues like Punjabi people or people from Indian subcontinent, they have this issue, or people from Middle East are having this issue? Do you have that sort of data where these people coming from?
Not on me, but we represent, as we said, a lot of people that live in the Wyndham area, in Hobsons Bay, in Maribyrnong, and with the LGAs, the local government areas that we support, it's a very cross-cultural mix of people. So I think in Victoria we've probably got the most multicultural society, and people from different faiths and also no religion as well, and different people that speak different languages as well. There can be issues that might be more prevalent in one community than others. You might see, for example, in some communities where people rely on their family a lot to mediate between them and their partner if things are not going well. So it's really important to note that if there's an intervention order in place, you might not get your family member to mediate on your behalf because it could be a breach of the intervention order. A lot of intervention orders will have an agency clause, they call it, and that means that you're not allowed to get a third party to do something you're not allowed to do.
That was my second question. I just wanted to ask you.
Yeah.
Is there a dispute between husband and wife, and they call police, and obviously there will be intervention order. But is there something between the dispute and going for intervention, or is there something in between, some dialogue? Is there provision of something like that?
Yeah. So with intervention orders, there can be exceptions in there for certain things. So if there's parenting or property issues that need to be discussed, for example, and it just depends on the specific case, but it might be that the respondent is able to communicate with the protected person only in writing, so by text message or email, and only if they don't commit family violence. In some cases, it might be they're only able to communicate through a mediator or a lawyer for those purposes, and only if they don't commit family violence while doing that. So it just depends. That's where you'll have the different conditions in regards to what can and can't be done.
This child included and they become adult in few years, will that change the intervention order?
If there's a child, the child
Becomes adults.
becomes an adult, yeah. So the intervention order, as a parent can only apply for the intervention order when the child is under 14, and the child can make their own intervention orders. When the child becomes an adult, it depends on how long the intervention order lasts for. So if it's a 1-year order and the child was 14 at the time of making it, then it would expire and someone would have to apply to extend it. Or if there is no extension, then it's not in place anymore. If the order was made and the child then turns 18, the order might have already. It depends on the duration of that order. So as I said, the duration is up to the magistrate to decide. It could be 6 months, it could be 12 months, it could be 2 years, it could be 5 years, it could be 10 years, it could be indefinite. It just depends on the specific case and the types of family violence that was experienced by that protected person or protected people, if it includes the children.
Just another question. The partner and husband wife, how legally they are seen differently? Partner to husband wife.
Okay, they're not seen differently. So it's a de facto relationship or domestic partner or a spouse. It's all included in the definition of family violence. So if you're living with someone on a domestic basis, then they are considered a family member for a family violence intervention order. Now, if you're married and you've separated or divorced, or you're a de facto couple that's separated, just because you've separated and you're no longer together, doesn't mean that you can't apply for an intervention order, because it includes those relationships, even if they're your ex-partner, or your ex-wife, or your ex-husband.
Now, just last question, because I've seen this number of times. When police comes, next day they take person to court, yeah? So I'm just wondering, is there any step before they take the intervention, or is there something else they can do, the police can do, or any other NGO type group can do?
Yeah, sure. So when the police, it depends on what's occurred. So if the police attend someone's home because a family violence incident has occurred, they'll speak to the protected persons, and they'll also speak to who has used the violence, the person that's used the violence, to see what the situation is. Sometimes you will have the affected family member that doesn't want anything to happen. If the violence was not extreme, police may consider that, but they generally take family violence very seriously, and they can apply either for a safety notice if they need to, or their intervention order. And when you go to court, the protected person may not agree with the police. They may not want the order, but because the police have made that application, it makes them the applicant. And that's why it's also very important for affected family members to still get legal advice, especially when they don't agree with the police, because the magistrates court all have duty lawyers that can assist both parties at court.
What is safety notice?
So the safety notice is a family violence safety notice. So those are, I spoke about it just before, that is when the police attend an incident. And for example, say it's after hours when the court might be shut, or it's on a weekend, and police think someone needs protection straight away, they can issue what is called a family violence safety notice, and it works in the same way as an intervention order, meaning that the respondent has to comply with those conditions and not breach it, because if they breach it, it becomes a criminal matter.
Any more questions?
Good evening, everyone. As Shake said, my name is Simiele. I'm a lawyer at Carbone Lawyers in Werribee, and we specialise in personal injury law. So the main areas being work cover, TAC, public liability, and medical negligence. We have offices all over Melbourne, including the city, Dandenong, Epping, Essendon, and Hyatt. We work on a no-win, no-fee basis, and it means exactly that. So any client or prospective client that walks through the door, they don't pay to hear from us, they don't pay throughout the life of the claim, they only pay at the very end if they're successful in getting compensation. And that's how the no-win, no-fee arrangements work. In the media, there are some prominent cases of ours which I'd just like to show you. This one is from a few years ago. A lady was injured on the Tullamarine Freeway when one of the signs fell on her car. The next one we have here is there was a shooting at Melbourne's Inflation nightclub. There was an action against the state of Victoria due to the actions of Victoria Police unfortunately shooting two innocent people who they believed had weapons on them when they in fact had not. Another one here is an apprentice that was hung upside down at work. The next one being a jockey whose career ended due to the design of, I should know the technical, the proper term for it, where the horses run out, the way the gate was designed was too low, and this particular gentleman had hurt his neck as the horse took off. We've got another gentleman here who was electrocuted on the work site of the block. And the last two cases here are really quite unfortunate ones. The first two cases of workplace manslaughter in Victoria, we are currently acting for the deceased families in an action against the negligence employers. So just goes to show that we're in the media, we deal with big cases, we're not scared to litigate, we're here to fight for injured Victorians and for their families. Now, as I said, we work we are working work cover, TAC, public liability and medical negligence. I'll start with work cover, one of the biggest areas for us. Some of the common injuries we see are back injuries, shoulder injuries, knee injuries, hearing loss, and what unfortunately is becoming very common now are mental injuries for stress and anxiety in the workplace. That really is on the rise, and that really comes about due to bullying, overwork and harassment in the workplace. So who can claim work cover? Anyone who is injured in Victoria. Even if you're a contractor, you can claim workers' compensation, provided that you do 80% of your work for that one organisation. So if you're an electrician, let's say, and you do a bit of work for Company A, a bit of work for Company B, Company C, you can still claim work cover, provided that 80% of your income is generated from your work from one of those companies. Okay? If you're a casual employee, you can still claim work cover. If you're on a visa, if you're not a permanent resident, you can claim work cover. There's this myth that we see time and time again of people coming through our doors and they say, but I'm here on a visa, my employer is telling me I can't claim work cover. That's incorrect. Okay? If you're working in Victoria, if you're receiving a pay slip, you can claim work cover if you were injured. Okay? And if your work cover claim is accepted, it entitles you to two no-fault benefits. The first being wages, it's referred to as weekly payments. They're paid at 95% of your average wage for 13 weeks. And then after 13 weeks, up until 130 weeks, they're paid at 80% of your average wage. Okay? The other no-fault benefit is payment of any medical expenses to treat your injuries. So that is GP appointments, medication, physiotherapy, scans, potentially surgery. As long as those expenses are reasonable and they're necessary to treat your work injuries, work cover will pay those costs. And as I said, they are no fault benefits. So it doesn't matter if you hurt yourself through your own fault, work cover will still accept your claim and they will pay those benefits. Then there are also lump sum payments, which many injured workers aren't aware of because, of course, the work cover insurer is not going to share that information with the injured person. The first is called an impairment benefit, which is a small lump sum payment. It's also a no-fault lump sum payment. All one needs to prove is that they have a permanent injury and that they have an impairment. If it's a physical injury, 10%, or if it's a mental injury, 30%. How that impairment is calculated is the work cover insurer will arrange an independent doctor to assess the worker, and they use a special medical dictionary that they follow to calculate that level of impairment. Obviously, the higher the impairment, the more money the injured worker walks away with. And if they receive this impairment benefit, it doesn't affect their entitlement to weekly payments and medical expenses. Many people think if they claim this lump sum payment, everything comes to an end. It doesn't. Those other no-fault benefits are ongoing. The other lump sum payment is called common law damages. This is where you need to prove two things. Firstly, fault on the part of your employer or someone else, another company. So let's just say you're a truck driver, you're delivering goods to a third party premises and you're injured on those premises. Your employer might not be at fault, but that premises that you've gone to may be at fault. You can make a claim against that third party. And the other thing that you need to prove is that you have a serious injury. And what tells us what a serious injury is whether one is able to work, how their day-to-day activities have been affected. So that might be that they have difficulty washing themselves, maintaining their house, getting dressed, playing golf, for example. They're all examples of, or indicative of whether an injury is serious. And the main thing with the common law damages claim, you do have 6 years from the date of your work accident to be able to submit that claim. Otherwise, you're forever precluded from doing so. So there is a strict time frame on that. There's been some recent changes to the work cover scheme that were made from the 31st of March last year, and they are quite draconian because it's narrowed the scope of new claims that have been accepted, and unfortunately it's kicking off workers from their weekly payments at a lot earlier stage than previously was. So the first change it's in relation to new mental injury claims. So as I said before, if one is suffering some stress and anxiety at work, you can lodge work cover. However, the sort of claims that have been accepted are significantly narrow. Effectively, unless someone is being bullied over a long period of time and they've reported it to their employer and they've got complaints in writing and they've seen a GP or psychologist about it, and their treating practitioner has also recorded that, those are the sort of claims that will be accepted. In the past, those claims will be accepted. Claims for overwork, disagreements amongst co-workers, stress that will ordinarily come about due to the general nature of one's work duties, those claims are no longer being accepted. So, as a lawyer, if I'm feeling under the pump because I've got a lot on my plate, if I were to lodge a work cover claim, that would be rejected, because that is a sort of claim that doesn't get picked up by the new legislative changes. But if you're a frontline worker, so a paramedic or a police officer, and you go to a traumatic scene, those sort of claims are being accepted, as are claims if someone is sexually harassed or assaulted at work or being discriminated against. The other significant change is entitlement to weekly payments after 130 weeks. In the past, the injured worker only needs to prove that they've got no work capacity. That test remains in place, but they also have to have an impairment of 21% or more. So as one approaches 130 weeks, the work cover insurer will arrange an independent doctor to assess them. Again, they will use this special medical dictionary to provide the level of impairment. If it's 20% or less, weekly payments stop. Even if the independent doctor says that you can't go back to work, if their impairment is less than 21%, the weekly payments stop. And we can help dispute the decision, and that's what we're finding now. 95% of workers are coming off weekly payments at 130 weeks because of that 21% impairment. It is very high. So it's important that if you are approaching that 150th week, that we do seek legal advice so you're aware of what your rights are to challenge the decision. TAC works quite similarly to work cover. It's also a no-fault benefit scheme. As long as you're injured on the road, whether it be as a pedestrian, you've been hit by a car, or you've been riding a bike, you can claim TAC benefits. And they're all for similar injuries. Your back, your shoulder, your knee, as long as it's arisen as a result of a transport accident. Okay? Just also on who can claim, we're seeing more and more e-scooter riders that are coming out with injuries. A bit tricky with e-scooters. If a vehicle has been involved in the riding of the e-scooter, that is the only time you can claim TAC. So if it's an e-scooter that collides with another e-scooter, those sort of claims will not be accepted. If you're an e-scooter rider and you've gone into a pothole in the road, again, that claim will not be accepted. It needs to involve another vehicle. So if you're riding an e-scooter and a car has struck you, that is an example of a claim that the TAC will accept. A TAC claim needs to be made within 12 months from the date of the accident. Otherwise, the TAC may not process that claim at all. There are exceptions, but it can go up until 3 years from the date of the accident, but it really needs to be lodged within 12 months from the date of the accident. The compensation, again, it mirrors work cover. You've got your weekly payments, or as it's referred to as loss of earnings benefits, that's paid at 80% of the average wage, and it's payable for the first 18 months from the transport accident. After 18 months, it's referred to as loss of earning capacity benefits, and that will only be paid after 18 months if you have no work capacity, so you can't do any job. And that will be paid up until 3 years. After 3 years, one needs to have an impairment of at least 50%. An example, we recently acted for a young boy who lost his leg below kneecap. He had an impairment of 50%. So that entitles him to these loss of earning capacity benefits for the rest of his life because he's got an impairment of 50%. And of course, the other no-fault benefit being the medical and life expenses. expenses. So again, GP appointments, physiotherapy, surgery, even household help. So if one needs a ramp installed at home, TAC can pay for that. If one needs a carer, TAC can pay for that. The lump sum claims, just like work cover, there's an impairment benefit claim and there's common law damages. That is where we need to identify that there was a negligent driver. And they all work the same. Impairment benefit, you need that impairment of at least 10%. Common law damages, a serious injury, and fault on the part of another driver. Even if one is partially at fault, that doesn't mean that you won't or you don't qualify for damages. There will just be a discount for any fault on your own parts. Okay? Public liability, again, injuries quite similar with work and road accident injuries, your backs, your shoulders, your knees. Who can claim? Anyone that is injured in a public place. So if you're walking down the street and there's a lip on the footpath and you trip, that's an example of a potential public liability claim. You're at the shopping centre, you're in the supermarket, you slip on a puddle that you don't see, on a piece of fruit. They're examples of public liability claims. Okay? With public liability claims, however, you do have 3 years from the date of the accident to issue court proceedings. So it's different to work cover in TAC where you've got 6 years, 3 years for public liability. Okay? With public liability, there's only one lump sum claim, and that is where you need to prove negligence. Okay? And one can be compensated for their pain and suffering. So they're examples of how their life has been affected. Do they require, or is their ability to dress themselves, engage in leisure activities being affected? Those are examples of pain and suffering. Loss of income. If someone has been unable to go back to work, or they're back at work but in a reduced capacity, or they're in a different role and they're earning less money, we can claim loss of income. We can also claim past and future medical costs. So if there's a possibility that someone will need surgery in 3 years' time, we can factor in the cost of that surgery. And of course, care costs. So if someone relies on the assistance of a family member or a friend, or they're paying someone, that is also factored into any potential pain. Medical negligence. Again, I'll repeat myself, similar injuries to everything that I've just touched on before. Who can claim medical negligence? If there's been any errors in surgery. One the other day I came across where a dentist had put the screw in a different spot of where they were meant to. And this particular client now had to have corrective surgery, and they've got quite significant scarring on their face. That's an example. Misdiagnosing a condition or a delayed diagnosis, that's an example of medical negligence. Errors with prescription, so they've given the wrong medication or the wrong dosage. They're all examples. Okay? And just like with public liability, the lump sum payments are just the same. You can be compensated for your pain and suffering, your loss of income, past and future medical expenses, and past and future care costs. And it's also got a 3-year limitation period. So 3 years from the date of the accident, or 3 years from the date of discovering the condition. So for example, I'll go back to this example of this gentleman who had the screw put in the wrong place. Let's just say that wasn't causing them any pain. Let's say that they weren't made aware of it. But then 6 months later, they're made aware of it. Their 3 years would run from that date. Not from the date of the operation, but from the date that they discovered the screw was put in the wrong place. So as I said, we're located in Werribee. We're here to help at 65 Wyndham Street. It costs nothing to know where you stand. You don't need to make an appointment. If just want to get some advice, you come in, it's free. As I said, it costs nothing to know where you stand. It could be the difference whether you can get a lump sum payment or not. Does anyone have any questions at all? No worries. Thank you.